Good morning. I'm Gary DeWaal, and this is Bridging the Week from March 21st to 25th, and today is March 28th, 2016. Navinder Sarao, a London-based futures trader, appears closer to facing trial in the United States for his alleged spoofing and manipulation of E-mini S&P futures contracts traded on the Chicago Mercantile Exchange and his purported role in partly causing the May 2010 flash crash following a judge's ruling last week in Mr. Sarao's UK extradition hearing. Separately, one firm was fined for supposedly violating enhanced speculative position limits in wheat futures, while an affiliated company was sanctioned for purportedly filing misleading information with the Commodity Futures Trading Commission about the alleged violation. Also, a broker-dealer challenged in a federal court the authority of the Financial Industry Regulatory Authority to bring an administrative action against it based on its alleged violations of provisions of the first U.S. securities law. It is now officially spring, so before I get too distracted by the nice weather outside and I forget to review last week's key developments impacting financial services firms, let's get started. Navinder Sarao, the London-based futures trader who, in April 2015, was sued by the Commodity Futures Trading Commission and criminally charged with contributing to the May 2010 flash crash, is closer to being extradited to the United States following a UK court decision last week. This is because the UK court found that the offenses for which Mr. Sarao was indicted in the US, spoofing and engaging in manipulative conduct, would be prosecutable in the UK, albeit under different laws. Last year, the CFTC charged Mr. Sarao and his trading company with engaging in spoofing and layering activity involving E-mini S&P futures contracts traded on CME for the purpose of disrupting the market in order to facilitate related trading that netted him profits in excess of $40 million US. This alleged wrongful trading occurred between April 2010 and April 2015. Mr. Sarao was also accused of wire and commodities fraud and manipulation in a criminal complaint in connection with the same activity. This action was filed in a U.S. federal court in Chicago by the Department of Justice. The U.S. sought Mr. Sarao's extradition in connection with this latter action. The final decision on Mr. Sarao's extradition will now be made by the UK Secretary of State, who has 2 months to consider the U.S.'s report following the court's ruling. Public reports indicate that Mr. Sarao will appeal the court's decision. The Commodity Futures Trading Commission filed and settled charges against Credit Suisse International for allegedly violating an augmented speculative position limit for wheat futures on several days in April and June 2009. The CFTC also filed and settled charges against Credit Suisse Securities, USA, for purportedly filing certain false information with the CFTC related to the purpose of Credit Suisse International's wheat futures positions. In total, the 2 Credit Suisse entities agreed to pay a fine of $665,000 US to resolve the CFTC charges, including $140,000 US by Credit Suisse Securities for its specific alleged violation. According to the CFTC, in September 2008, Credit Suisse Securities requested the CFTC to grant Credit Suisse International a hedge exemption to its then prevailing 6,500 contracts all-month speculative position limit in wheat futures. This request was apparently made to accommodate the firm's clients that were liquidating commodity swap positions with certain counterparties experienced financial difficulties. The CFTC claimed that despite granting Credit Suisse Securities' request on several days during the relevant time, Credit Suisse International still exceeded its enhanced position limit. Subsequently, in March 2013, Credit Suisse Securities, on behalf of Credit Suisse International, submitted information to the CFTC that the agency alleged was different than information the firm contemporaneously provided the CFTC in 2009. Based on the new information, Credit Suisse International would not have violated its augmented position limit at the relevant time. However, the CFTC claimed that the new information was materially false or misleading by including inflated swaps information. Scottsdale Capital Advisors Corporation, a Securities and Exchange Commission registered broker-dealer, and certain of its senior offices sought an injunction in a federal court in Maryland against the Financial Industry Regulatory Authority from proceeding against them in a disciplinary action alleging their violations of the Securities Act of 1933. This law was the first U.S. federal securities law and generally governs the issuance of securities, including registration and disclosure requirements. Plaintiff contended that FINRA had no authority to prosecute claims under the Securities Act because its disciplinary authority is limited to matters that might constitute violations of the Exchange Act of 1934, a provision of U.S. law that established the SEC, authorizes national securities associations such as FINRA, and generally governs the secondary trading of securities, financial markets, and their participants, including broker-dealers. FINRA commenced a disciplinary action against plaintiffs in March 2015, charging violations of a provision of the Securities Act that generally prohibits the public distribution of an unregistered security without an exemption. The firm was also charged with not maintaining a supervisory system reasonably designed to detect the alleged violation. Plaintiffs argued that the federal court should grant their requested injunction without them first proceeding with the federal discipline action and permitted appeals through a federal administrative process, the SEC, and then potentially a federal court. This is because, said the plaintiffs, their challenge is a jurisdictional challenge and not, quote, the type of claim Congress directed only to the administrative system, end of quote. And finally, J.P. Morgan Chase Bank and J.P. Morgan Ventures Energy collectively agreed to pay a fine of $225,000 US to resolve charges brought by the Commodity Futures Trading Commission that, from at least March 1st, 2013 through April 30th, 2014, they failed to file accurate large trader reports with the CFTC as required by law, reflecting their reportable positions in physical commodity swaps. The CFTC charged that during this time, the entity's large trader reports, quote, routinely contained errors, end of quote, and were not submitted at all on 2 days. According to the CFTC, during the relevant time, the firms proactively advised the agency of issues with their large trader reports, and further researched and corrected their large trader reporting systems after staff of the CFTC advised them of potential noncompliance issues on January 2nd, 2014. The firms also submitted corrected historical large trader reports after the CFTC notice. Both firms were provisionally registered as swap dealers during the relevant time. Make mistakes regarding a new rule, be good guys and come clean, fix things and still be fine. Something seems wrong. Well, that's it for this week's edition of Bridging the Week. As always, there's more information on each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and until next week, have a great week and ciao.